Garland versus Cargill. That's right, we're live, and as you may recognize, I'm not quite at my office. I'm at the beautiful Denver International Airport. I was stepping onto a flight, which I was barely able to download the PDF. I've read the entire decision, the entire dissent. I'm going to break it down to you in 3 easy points that you need to know, including one thing I don't like and one bombshell that I love, and I promise if you're watching this, you will too. So stick around to the end until we get there. Here's basically the 3 things that you need to know that went on in this decision. I'm going to have it linked up eventually in the description box below. Number 1, what Justice Thomas went through is, at the end of the day, the statute in question that was set up by Congress, not the ATF, because we have the law, and then we have what the ATF, what different agencies and sub-agencies do. That's rulemaking. And love it or hate it, and I'm not here to talk about that, they are allowed to do that. But they are only allowed to clarify rules, to interpret rules. They're not allowed to exceed their statutory authority. And that's exactly what has happened here, according to the good old U.S. Supreme Court. Why? It goes back to the fact that the statute talks about the fact of, look, we're talking about one function of the trigger per shot. One function of the trigger per shot. That's what Congress said. Now, what ATF said in their rule, though, is actually something quite different. What ATF in their rule pulled out was the fact that we're talking about, look, without additional physical manipulation of the trigger by the shooter, we're talking about things that go into analogous motions. Something that I found really interesting in the dissent of this case is that they really avoided using the words function of the trigger or even that T word, trigger. They kept referring to it as an internal mechanism. And of course, they're doing that to try to whitewash the fact of, look, a trigger is a very distinct device. Hammer, disconnector, all that kind of stuff. That's what composes the trigger. The bump stock, not the trigger. That's something entirely different. And that's what the majority in the 6-3 decision, of course, with the decision written by Justice Thomas, hammered in the fact of, look, at the end of the day, a bump stock accelerates the function of the trigger. But it is not in and of itself the function of the trigger. It is distinct and separate from the function of the trigger. So it offers an input to it. One of the interesting things that, of course, they really hit on in the majority decision, and this all kind of goes into that kind of the big first point, which they spent the majority of the decision elaborating on, of look, and they went through the internal mechanism of how the disconnector attaches to the hammer, had those backwards, and then you have the notch and all that kind of stuff, and then to actuate it again, to actually function the trigger again and therefore fire another shot, you have to, of course, pull the trigger. They really went on in the majority decision about the fact of, look, among a few things, the dissent in the ATF agrees that if you manually bump fire, say using a belt loop or something like that, that in and of itself is actually not a machine gun. That is not full automatic fire. And it's interesting that in oral arguments and in the briefs, they conceded that fact. And the majority leaps all over them for this point, because of course, how on the one hand can you say, well, look, that is not full automatic fire, but on the other hand, a device that basically does that or assists you in doing that, because you still, of course, have to apply forward pressure on the stock and all that kind of stuff, or rearward pressure on the firearm. How is that in and of itself any different? And they're leaping all over them for the fact that they are being internally inconsistent. Another big point, and reason number 2, is they basically said, look, let's concede in a hypothetical universe where this is all part of the function. The congressional language under the machine gun statute says automatically. What is going on that's automatic if I have to do additional manual inputs into this by actually, of course, manipulating the stock so that it is used properly? That's not automatic. In fact, that's the definition of not being automatic. If I have to do it, it is not automatic. That's called manual. And that directly flies in the face of the machine gun statute. Okay? The third thing, and this is something that the dissent brought up, and I have a feeling that the majority went into this as part of their opinion to kind of push back on that, deals with what's kind of called the rule or the principle of ineffectiveness. And it goes something like this. because it's not something that we really talk about too much. The rule of ineffectiveness goes to the fact that when Congress or any kind of legislature passes a law, we generally want to interpret and try to uphold that law to buttress it against folks who may be looking for technical and easy workarounds. So we don't want people to be able to, Congress pass a law, then people develop some sort of technical loophole into it. So basically what the dissent and what the ATF was saying, among other things, is look, this bump fire, this bump stock, this is basically would run afoul of the rule of ineffectiveness because this is just a technological loophole that they're using to exploit that was never foreseeable. And the majority says, you're wrong. You're wrong. And they say it for the simple fact that, look, Congress, when they passed this, the National Firearms Act, right, which tuned up, juiced up the regulation on this, which is, of course, subject of an entirely different conversation, but we're going to touch on that a little bit. They could have regulated the automatic fire saying, look, any device that accelerates the rate of fire or any firearm that's capable of firing more than X rounds per minute, they could have looked at the output. But they chose not to, Congress. They looked at the input. Not only did they look at the input, but they very specifically keyed everything into the trigger function. That's what they did. That's what they hammered on. And that's what the ATF must regulate within. Now, of course, they also go ahead and point out at a few different points in the decision the fact that, look, if this was so ineffective, if this was just some sort of technical loophole, then why did the ATF approve this nearly 10 times across the majority of a decade? Why did they do any of that? And of course, the Supreme Court also leaps all over them, as well as different legislatures who went on record as saying, yeah, this is all going to be overturned someday. We need to pass something by Congress. So basically, the Supreme Court sets up the goalpost as saying, yep, you can't do this. It's going to have to be done by Congress. Now, I mentioned something that I don't like. There's actually two things that I don't like. One is the fact that you don't have to read very far in between the language here to understand that the Supreme Court seems pretty comfortable with at least the National Firearms Act as it relates to the existence of machine guns. So I've been on record before. I'm going to add to it here. I'm not asking you to like it. I'm not saying I like it. But I don't think we're going to see the NFA overturned, at least as it relates to machine guns. Short barrel rifles, short barrel shotguns, maybe AOWs, definitely suppressors, game on. But at least as it relates to machine guns, between this and some other things I've documented in other videos, I'm a little skeptical of it. The second thing I didn't like was the fact that they very narrowly tailored this decision. What have you not heard me talking about? You have not heard me talking about the Brune history and tradition test. You haven't heard me talking about any of those sorts of things. You haven't heard me talking about common use, right? Nothing like that has entered the discussion. They basically took the approach of, this is a really straightforward and obvious call of what we would say in law statutory construction of, here's how the statute's written, here's how the ATF has decided to clarify it, of course clarify being the operative language because that's how the ATF has to call what they choose to do under the Administrative Procedures Act, better known as the APA, because of course if they say, yeah, we've totally reversed our decision, then it could possibly run afoul of the arbitrary and capricious standards, okay? So they didn't push back on Chevron either, okay? This case did not go into Chevron. So the Supreme Court had an opportunity to maybe bait the hook for a machine gun challenge. They didn't do that, and in fact, on the contrary, they seemed to say some things, or they seemed to take it as more or less a given, both in the majority and the dissent. Alito did write a concurrence, but the concurrence didn't really do anything interesting here. And of course, he also joined the majority to make it that 6-3. So I don't think we're going to get the machine gun overturned. And the Supreme Court could have used this as an opportunity to really kind of push back or carve out some sections on Chevron. They chose not to do that either. They ruled this narrowly on the grounds of basically statutory construction, the ATF exceeding their statutory authority. I promised you a bombshell. So here it is. Before I get there, be sure to hit that like button. I don't have Derek behind me. I have behind the camera my lovely wife, Jen. Please be sure to thank her in the comment section if you have not already had a chance to do so. And I'll be selfish. Please click like to show your support for her amazing cam work. I've seen her wiggle her nose a few times trying to push back itches. She's smiling right now because she knows it's very true. This is the one time I can say something and she won't get the better of me, so I have to take advantage of it. All right. So be sure to hit that like button. Leave your comments down below what you think will happen next with the ATF. Is this going to be the start of good things to come, or is this going to be the end of the good times? Of course, we've got the Rahimi decision and more cases coming up on the docket. We will, of course, continue to cover them. Here's the bombshell. The bombshell was an introductory paragraph within the dissent written by Justice Sotomayor. Exactly no friend to the Second Amendment, at least not so far, okay? She referred to AR-15s as being commonly available, right there in the opening paragraph of her dissent. Commonly available. Well, that's really interesting because I can agree with the fact that America's most popular firearm, America's most popular rifle is absolutely commonly available. But why is that important? Because, of course, it gets back to the DC versus Heller, it gets back to the Catano test, it gets back to the fact that, look, we are going to have some major laws going up to the U.S. Supreme Court, probably the one from the National Association of Gun Rights coming out of the Seventh Circuit, challenging the Illinois so-called assault weapons, of course, talking about modern sporting rifles, and normal capacity magazine ban. And we now know that there's 1 billion magazines, so that's got to be in common ordinary use. But we know that the constitutional test, and I hope you all can hear me because, of course, there's loudspeakers going on. The constitutional test to determine whether or not a firearm is going to be deemed to be good to go. It's a two-parter. Number one, is it commonly available? Is it ordinary? And then secondarily, and this is really going to be the battleground because I don't see how you can challenge, especially now that this U.S. Supreme Court has taken judicial notice, seemingly, of the fact that AR-15s are commonly available, that now, of course, we're talking about, are they going to be dangerous and unusual? I have been looking into research on the history of dangerous or unusual, going back hundreds and hundreds of years. If you want me to fast track that, let me know in the comment field below. I will try to do so. And of course, I'm going to close with my ever popular quote of the day, which I'm going to have to read off my, my normal phone here. Quote, "Children should be educated and instructed in the principles of freedom," from John Adams. I appreciate you all for checking in. I will do more on this next week when I'm back in the office and not in Denver for my brother-in-law's wedding. I will see you next time.